Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. Today we're talking about default judgments. Sometimes when a person is served with a complaint in a court case, they read through it and think, this is crazy, this is ridiculous, the case has no merit, so they do nothing, they ignore it. They tend to ignore the first page, which informs them that they have 20 days to respond, and if they don't, a default judgment could be entered against them. They mistakenly believe a judge will throw it out, or they believe the court system moves so slowly that they can delay taking action. But that's not how it works. The next thing that happens to them is they receive another document in the mail, the 10-day notice. This notice informs the person, the defendant in the court case, you in our hypothetical, that if they don't act within 10 days, a judgment may be entered against them. Now, for many people, this finally motivates them to contact an attorney to find out what this is all about. However, too many people remain in denial or continue to delay, and before they know it, they receive another notice in the mail informing them a default judgment has been entered against them. Now, they finally take some action, but it might be too late. Once a judgment is entered against you, it's very difficult to have it removed or stricken from the record. There are deadlines. You only have 10 days from the date the judgment is entered to seek to strike it under the rules, and then you must show a compelling reason for the delay and put forth a viable defense. If you delay beyond the 10-day period, it's even more difficult and extremely difficult after 30 days. We just recently had an out-of-state client hire us because he received a default judgment in the mail. The day after we were hired, we filed documents in court requesting the judgment be stricken. We filed this document over 20 days after the judgment was taken. We did succeed in convincing the judge to strike the judgment from the record. That's because the plaintiff, the person who obtained the judgment, falsely reported that he had filed and served a complaint upon our client, which he did not. So the judge struck the record. So if there are defects in the record or failures by the person who has obtained the judgment to follow the rules of civil procedure, we might be able to strike off that judgment. But you have to act right away. The more you delay, the less chance you have of getting a court to strike off the default judgment. If you do nothing, the court system can move swiftly, and it's possible for a judgment to be entered against you 30 days from the date the complaint was filed and served. If you don't file the necessary documents in court on a timely basis to challenge the judgment, then it will stand. And that means the judgment creditor, the person or company that obtained the judgment against you, can now move against and seize your personal assets, your home, your car, your bank accounts, among others, in order to satisfy the judgment. So do not go into denial, do not delay. If you get any legal papers in the mail, contact your attorney. You're welcome to contact Scaringi Law right away. If you get a default judgment in the mail, call us right away so that we can consult with you to find out if you have grounds to challenge and strike off that judgment. You can reach us at 717-657-7770. Well, that's about all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about the law. Thanks for listening and enjoy your lunch.